We good? Okay. All right. Hi, folks. We're going to get started here. Welcome to New America, and thank you for joining us at today's event. Happy 30th birthday to the Computer Fraud and Abuse Act, perhaps the worst law on technology. I am thrilled to be moderating today's panel, but first I just want to briefly introduce everyone. So I'm Robin Green. I'm a Policy Counsel and Government Affairs Lead at New America's Open Technology Institute. I work mostly on cybersecurity, surveillance, and privacy issues. OTI is a program at New America. We work at the intersection of law and technology and policy to ensure that every community has equitable access to digital technology and its benefits. We promote universal access to communications technologies that are both open and secure, using a multidisciplinary approach that brings together advocates, researchers, organizers, and innovators. And we are thrilled to be hosting today's event with Future Tense. Future Tense is a partnership between New America, Arizona State University, and Slate magazine to explore emerging technologies and their transformative effects on society and public policy. Central to that partnership is a series of events that take an in-depth, provocative look at issues, while little understood today, will dramatically reshape the policy debates of the coming decade. Today's discussion will be just that, but we're actually going to start in the 1980s instead of with today. The 80s was actually a really big decade for technology. We tackled time travel with Back to the Future. We had Walkman the size of books and VCRs the size of briefcases, although I'm looking at this room and looks like there are a few people who literally may have never seen a Walkman or a VCR, so I'm dating myself just a little bit here. But it was also a really big decade for Congress and technology. Our Congress passed laws that would still have reverberations today. Congress made laws meant to protect our privacy and infrastructure in a new technological age. In 1984, we saw the passage of the Electronic Communications Privacy Act, ECPA, which sought to protect the privacy of our digital communications, which were only just beginning at the time. Then in 1986, Congress responded to the fact that our world may soon be dominated by computers and thus threatened by malicious hacking, so it passed the Computer Fraud and Abuse Act, the CFA. The problem is that since then, neither law has been changed, and both are woefully out of date in the wake of not just personal computing, but also the internet and the ubiquity of connected devices. These laws have not kept pace with the amount of information that is now available online and the security challenges facing innovators who develop and maintain new technologies. While just this year, the House unanimously passed a bill to update ECPA, which is still pending in the Senate, Congress has barely scratched the surface trying to grapple with how to update the CFAA. But after 30 years, updates are gravely needed so that malicious hackers who pose threats to computers and networks face reasonable consequences for breaking the law, but also so that many hackers who are good guys and gals and average internet users can help to better secure our systems or just use online products and services without fear of violating the CFA. Congress may not be focusing on these issues, but advocates, researchers, and practitioners all over the country are taking them head on and trying to find solutions. And we have some of the best and brightest with us here today. So without further ado, let me introduce them. We have Josephine Wolff, who is an assistant professor of public policy and computing security at the Rochester Institute of Technology. She's also a fellow at New America's Cybersecurity Initiative and a faculty associate at the Harvard Berkman Klein Center for Internet and Society. She'll be starting us off with an opening address, and after that, she'll be joining our panel discussion. On the panel, she'll be joined by Orin Kerr, the Fred C. Stevenson Research Professor of Law at George Washington University, and Justin Peters, author of the book The Idealist, Aaron Swartz, and the Rise of Free Culture on the Internet, and a correspondent at Slate. So before I kick it off to Josephine, I do just want to go over a few housekeeping items. If everyone could please be sure to silence your cell phones, that would be great. And then also, you can follow this discussion online using hashtag CFAA30, or follow us on Twitter at @FutureTenseNow. So Josephine, the floor is yours.
All right, well, thank you, Robin. Thank you all for joining us today. I want to get to the panel discussion, so I'm going to be brief. I just want to outline for you some of the reasons why I think this is a really fascinating law, why I think it's a really important law to be thinking about in its historical context, to be marking the occasion of its anniversaries and understanding how the past 30 years have changed the way that we might understand, interpret, and think about what makes sense for a computer crime law. It's a really interesting law in itself. It's also emblematic of a lot of the challenges related to regulating technology, and particularly computer technology, more broadly. So I want to talk a little bit about 5 issues that I'm hoping we're going to touch on today in our conversation. The first 3 are really related to what does the Computer Fraud and Abuse Act mean, and what do we want it to mean? What's the best version of this law we can imagine given the framework that Congress laid out 30 years ago? The Computer Fraud and Abuse Act, for those of you who are not familiar with it, really centers on 2 ideas about what makes use of a computer illegal. And they're access without authorization or in excess of authorization. So what you think is illegal in this country to do with a computer really depends on how you interpret those words. And helpfully, Congress does not include in the actual text of the law definitions of access or definitions of access with authorization or without authorization. So there's actually a lot of richness in discussions around what that means, what it means to access a computer, what it means to have authorization to access a computer. And in particular, there's an ongoing and still fairly unresolved debate, I would say, about whether that access with or without authorization extends to what we might think of as rules written in English. If you agree to a terms of service agreement, which you've probably done many times in your life, if you agree to an employer's acceptable computer use policy, if you receive a letter from a website telling you what you can or can't do on those websites, are those rules written in English? Do those circumscribe the kinds of authorization you have under this law? Or does it really only apply if what you're doing is something technical? If you're trying to circumvent some kind of technical or physical control, a password requirement, a firewall, something that's actually involving you getting into the code, getting into some of the technical controls, and trying to get around them. So that's one issue I want to talk about. What do we mean by access without authorization, access in excess of authorization? Do we include just technical activity in that bucket, or is it really much broader? Does it apply to the kinds of things written in English that tell us what we should or shouldn't be doing with computers? Even if we can agree on that, and I'm not sure we will, and certainly the courts haven't yet, even if we can agree on that and we say we're going to restrict the CFAA to only be about technical stuff, only be when somebody really goes into the guts of code and finds a vulnerability, there's a second set of issues that's really important, which is how do we carve out exceptions for security researchers? Right? We don't want criminals taking advantages of vulnerabilities in the software to steal money or do lots of other terrible things. But we do want some smart people to be looking at the computer technology we rely on and thinking about, are there vulnerabilities here? How do I test them? How do I report them? How do I do this in a responsible fashion? And ideally, most of us would like there to be a way to do that without threat of civil or criminal action under the CFAA. So I hope we're going to talk a little bit about how do you carve that out? How do you do that in a meaningful way, given that a lot of the tools and techniques that legitimate sort of no harm intended security researchers use are pretty much exactly the same as the early stages of what we might think are really criminal acts, things that should be illegal under this law. And finally, once we've resolved both of those issues, I want to talk a little bit about penalties and get a sense from our distinguished panelists about what's the appropriate punishment and how should we be calculating it? How do we calculate something like the damages associated with a computer crime? How do we understand what's proportional, what's rational, what's reasonable, and what's effective as a deterrent if we think that's one of the roles that the CFAA should be serving? So those are 3 questions related to definitions, related to security research exceptions, related to penalties that are really sort of saying, okay, we've got what Congress came up with in the 1980s. How do we make it a little better, a little clearer, a little bit more up-to-date and useful? I also want to talk a little bit about 2 issues that take a slightly different approach and say, what if we started over in 2016, knowing what we know now about computers and how they're used and who uses them, and we tried to conceive of the best computer crime law we could, setting aside the framework of the CFAA. And the 2 issues I want to raise there are, what is this law for? What are the cases, what are the circumstances where we say there's no other piece of law that really clearly addresses this issue? And one of the issues that does come up often in CFAA cases is you see judges, you see lawyers saying things like, this is really about appropriation of trade secrets. This is really about some other area of law. There just happens to be a computer sort of peripherally involved because it's hard to do anything these days without a computer, much less commit a crime. How do we sort of conceive of the bucket of cases that are really computer crimes And what do we bound and say, this is where we need a law that specifically focuses on this, not just a law that can be kind of called into play whenever there's a question of some sort of computer use that was related to something bad. When we figured that out, which we may or may not, I want to talk a little bit about the model that the Computer Fraud and Abuse Act is built on, which is really a trespass model, right? The analogy that Congress is thinking about 30 years ago, more than 30 years ago now, when they start conceiving of this law, is it's illegal to trespass on somebody's property. It's illegal to break and enter, even before you've stolen something, right? There are lots of things that's already illegal to do in the 1980s, including steal money and various other things that we've seen people use computers for. So the analogy is this access, or access without authorization idea, is supposed to kind of provide a virtual analogy to trespass, breaking, and entering law. And I think there are a lot of questions now as we look at how people use the internet, how people think about the internet, of whether that's the best model. Whether we think about computers, whether we think about computer networks as this is my property, that's your property, I'm not allowed to trespass on yours. And if not, what might be some other models for thinking about sort of the right metaphor, the right framework for trying to put together a computer crime law. So with that, I want to invite the rest of the panel up and start talking about some of these issues.
All right. Well, thank you for getting us started, Josephine. So I just kind of want to kick it to the panel to start off and say there was a lot packed in to this introduction. Obviously, the Computer Fraud and Abuse Act is a really complex law with really differing interpretations in the courts and not necessarily a tremendous amount of guidance within the text, for better or worse, for how it should be interpreted. So, how have you guys seen that play out? What are your takeaways from Josephine's opening remarks, and what do you think the big issues are that need to be grappled with?
Well, I'll speak to my own particular area of expertise, which is one guy. The book I wrote was about the computer programmer and internet activist Aaron Swartz, who killed himself in January 2013 after being under indictment for about a year and a half for crimes committed by him when he used the network at the Massachusetts Institute of Technology to download without explicit authorization about 4.7 million academic journal articles from the nonprofit database JSTOR. Now, thanks to a series of unfortunate events, these incidents ended up in the hands of the U.S. Attorney's Office in Boston. Thanks to further unfortunate events, the U.S. Attorney, the AUSA, who was in charge of computer crimes, was a guy who was very avid about prosecuting computer cases. And what happened was, after about a 6-month fact-finding period, they handed down a 4-count criminal indictment. 3 of the counts were CFAA charges. That the CFAA charges each carried a maximum penalty of 5 years in prison. About a year later, they came back with a superseding indictment that raised the charges from 4 to 13 and raised the maximum penalty when all was said and done from 35 years to 95 years. Now, it's important to note that no one ever gets the maximum penalty in these cases. When someone is prosecuted under the CFAA or basically any law in federal court, we're really dealing with the federal sentencing guidelines, right? And the guideline sentence for what Aaron Swartz did was somewhere around 7 years in prison. But sort of the statutory maximums are very much used to sort of encourage someone who might think they have a case, might want to, take the risk of going to court to accept a plea offer. And Aaron Swartz would not accept that plea offer, largely because he felt like, well, what I did perhaps wasn't actually like a crime. It may have run afoul of the CFAA, but it was motivated primarily by this sense of curiosity, and it was not done sort of out of malice. The CFAA does not really distinguish between transgressions done out of malice and transgressions done just because you're a curious guy who might want this for any number of reasons. one thing led to another, and he committed suicide, which is where I began. And that's sort of where my book starts off, to look at the history of these laws. Now that I've given you a summary of my book, which is coming out in paperback in January, I will just say this. There's a lot of interesting stuff to talk about here. In this little speech, I've pretty much exhausted the limits of my expertise. I'm not a lawyer, I'm not a professor. I'm super honored to be sitting here between Orin and Josephine. Now, I will just say that a lot of the rhetoric around this law and a lot of the people who want to change it, it has a lot to do with this notion of what internet culture is and what it means, and really trying to get legislators to recognize that there is such a thing as internet culture, that the internet does not just exist as sort of a profit center for companies that want to sell, their widgets or, accumulate your data online. And whenever Congress has legislated on computer issues, they're almost always legislating from the standpoint of people who want to circumscribe your activities for reasons of profit. And that's, in my estimation, one of the big reasons why we are where we are today.
So let me step back and ask a question that Josephine implicitly asked, which is, should there be a Computer Fraud and Abuse Act? Should this law even exist? And I think the answer is yes. If this law did not exist, we would be on a panel, and the top subject of the panel would be, can you believe it's 2016 and there's no law protecting the privacy of your email accounts, of your laptops, of your desktop computers, of your phones? Congress is obviously corrupt, and they don't even understand that they need to protect computers and protect the privacy of computers from people that are trying to access your computers, break into your computers. And it's outrageous that Congress hasn't done this. Congress in 1986 enacted this law because courts were struggling to figure out in the period before 1986, what do you do with this sort of new kind of computer trespass that is not obviously covered by any other law? The easiest example, I think, is everyone in this room has an email account, or at least a Twitter account, some kind of online account protected by password. If some outsider just wants to find out what's in your account and they guess your password and look around, that should be a crime, right? That's some kind of trespass. Prosecutors tried to figure out in the era before the Computer Fraud and Abuse Act, what is that? What crime is that? And they had a real problem, and the real problem was they couldn't charge physical trespass because criminal laws on physical trespass are about human entry. You have to sort of physically go into the place, and obviously outside of Tron, that was not happening with computer accounts. Okay, a couple Tron fans, good, always good to see. And so then they actually tried charging unauthorized access cases as theft on the theory that if you were harmed by somebody trespassing into your account, then you lost something. If you lost something, it was kind of taken from you. If it was taken from you, it was like a theft, and therefore the person committed a theft when they broke into the account. And it was a horrible sort of Rube Goldberg-like way of prosecuting misuse, which basically would lead appellate courts to say, like, does this look like a bad case years after the prosecution was brought? And then they would say, yes, either there was a theft or there wasn't a theft. And it was widely realized that just doesn't make sense. What we're really talking about is breaking into somebody's private space. It is a classic trespass idea. There should be a computer trespass statute, and that's why the federal government and all 50 states have them. In my mind, we're really dealing with a problem of interpretation. The concept of a computer trespass statute makes a lot of sense. The hard question is, what counts as a computer trespass? And it's hard for two different reasons, I think. One is that we have, of course, a networked world where we often allow people to use different machines. You wake up in the morning, you use hundreds, if not thousands, of computers within the first 20 minutes you're awake. You're checking your Facebook account, you're checking your email, you're surfing the web, checking the news. We're constantly sending communications to other computers, and that raises the question of, okay, well, what does this ban on access without authorization or exceeding authorized access really mean? And so I think that's a judicial interpretation question, and the reason why the CFAA is controversial is just courts have really struggled to figure out what does that mean. If you're spending your entire day accessing computers you don't own, that question of what unauthorized access means becomes incredibly important, because it's sort of the line between just routine computer use and potentially going to jail. That's big. The other problem with the CFAA is that Congress, in its infinite wisdom in the 1990s, added a civil remedy. The thought was, kind of funny historically, but the thought was people were going to be using computers so often in the future that the government was going to be overwhelmed with CFAA prosecutions. There were going to be thousands of CFAA cases, and you needed to have a civil remedy to allow victims of hacking to sue the hackers in order to deter the hacking that couldn't be deterred because the government couldn't bring that many cases. Now, this is funny in retrospect because the problem with the CFAA is it's very hard to catch people. And so the federal government only brings about 100 CFAA cases a year today, about the same as it did in the late 1980s, early 1990s. Maybe it was 30 or 40 at the time. Now it's 100. And the civil remedy ended up being a fantastic tool for businesses to get into federal court in business-to-business litigation. They say, you looked at my website. I didn't want you to look at my website. Maybe I put up a term of service that said you couldn't look at my website. You not only stole my trade secrets or competed in an unfair way or took my copyrighted files, you hacked into my computer by breaking the rules, and then courts are faced with the interpretation of unauthorized access primarily in civil cases where their instincts are totally different than they are in criminal cases. So we get these really broad interpretations of unauthorized access in contexts where it doesn't seem that crazy, because the courts are not thinking like, oh, the company could go to jail. They're just thinking like, there's a civil injunction, don't keep doing that, different stakes. So we have a vague statute, and we have the cases coming up in contexts where the true significance of the statute is obscured because it's a civil case. And that's why I think we're here. It's just difficulty trying to figure out what does unauthorized access mean. And I want to, before I finish up, sorry I'm going on at length, but Justin mentioned the Aaron Swartz case. I think in a lot of ways the Aaron Swartz case is not the best example of problems with the CFAA. And maybe the best way of thinking about this is that Aaron Swartz was extremely well known. He had a lot of very influential and high-profile friends who had a lot of access to media sources. And until he committed suicide, his prosecution was well known in the community and was almost never commented on. Very few reactions. Until he committed suicide, at which point there was an extraordinary uproar, and this case was outrageous. How could the government bring this case? He was facing 90 years in prison. All this reaction follows the suicide, but there was a surprising silence before his suicide. And I think the reason for that is that this was not one of the close cases under the CFAA. This was not a case that sort of drew out this controversy over what the CFAA means. If Aaron Swartz had not been Aaron Swartz, it was not something that would have drawn major attention. I don't think he was just kind of exploring. This was a big cat and mouse game between him and the university. It was part of what seems to have been a broader agenda. It was not just a few documents. It was millions of documents. And also at sentencing, it actually was hardly clear to my mind what the federal sentencing guidelines would have said in the Swartz case. It might have been that if he was convicted, the sentence would have been probation. So this was not actually the best example of kind of the controversies that we're encountering with the CFAA. And I think the effect of the Swartz case has been to draw in a lot of people into the debate, and it has effectively locked Congress into inaction. Before Swartz, it was more likely that legislation could be passed. Now, not only does no legislation ever pass Congress, but there's opposition to the government when the government says we want to expand the CFAA. There's like a good chunk of people that say you can't do that. And that's why I think we're really dealing now with judicial interpretation. It's in the courts rather than something going on in Congress. But I'm not sure Swartz was the best example of the kind of uncertainty and hard cases that we're grappling with.
So what are some examples of the cases that you think sort of best highlight instances where the law really just isn't keeping up with what it needs to do?
Yeah, so one example of this, there's a circuit split on whether it's a violation of the Computer Fraud and Abuse Act to access a computer in the face of a warning that says you can't do this, such as terms of service or employee restrictions. The Ninth Circuit has said it's not unauthorized access if you violate written restriction, for example, an employer restriction. You can only use your computers for workplace purposes. The 11th Circuit has said that it is a violation of the CFAA. The Second Circuit then said it's not. The Fourth Circuit said it's not. Other circuits have said it is. It's a deep circuit split on whether unauthorized access is triggered by just a written warning that says, you can't do this. And that split became even more intriguing with a recent case, Facebook versus Vachani in the Ninth Circuit. Full disclosure, I represent Vachani, the Power Ventures, the losing side in the circuit court. In that case, the Ninth Circuit panel said, yes, if it's terms of service or some sort of general written restriction on the computer, you can violate that without unauthorized access. On the other hand, if you receive a letter saying that your acts violate the terms of service, that's different. That, if you continue to access the computer after you receive the letter, then that is unauthorized access, and exactly where the line is between getting the warning on the computer and the warning in the letter is a mystery to me, which is why I think the Ninth Circuit en banc needs to rehear the case. But courts are just really struggling with this question of, what is unauthorized access? Does that mean, you break in? Does that mean the owner said, please don't do this, and you did it anyway? It's tricky in part because there's physical world analogies that can be drawn on both sides, and so you have to figure out which physical world analogy applies and how do you make that decision. And I just think you have a lot of courts in good faith just trying to figure out what the statute means and just disagreeing. So this is, I think the U.S. Supreme Court is going to finally have to resolve the unauthorized access question at some point in the next term or two. It's just a really deep circuit split. And interestingly, the U.S. government has lost on its preferred meaning of the CFAA in the two circuits where it matters the most, the Second Circuit and the Ninth Circuit. And they had the opportunity to file a cert petition in the Second Circuit case, the Valley case, just last year, and they declined that opportunity. They decided not to bring a cert petition. And if they didn't bring the cert petition in that case, I suspect that means they don't want to bring this before the Supreme Court, because they know that the Supreme Court has been really zealous about enforcing the rule of lenity and having narrow construction of criminal statutes. And I suspect the Supreme Court would adopt a narrow interpretation, maybe a little harder after the death of Justice Scalia, who was really strong on the rule of lenity. But I think the Supreme Court would resolve this in the way that at least I think, and probably most people here think, is the better way, the narrow interpretation. But right now there's just incredible uncertainty on the question.
Yeah, so, and for those in the audience who don't really understand a lot of the legal jargon, a circuit split basically means that the law is going to be different in different parts of the country, depending, wherever the court has jurisdiction, the states where it operates, that court's decision will operate there, and then it can be different in other places. So the fact that the Supreme Court hasn't resolved this yet by hearing a case on it and coming out with a decision does leave a lot of legal uncertainty for folks, especially people who maybe are less concerned with breaking the law in the sense that they're not seeking to break the law, but maybe they're seeking to improve security. And to do that, you have to hack and actually find the vulnerabilities like what you were talking about. Can you talk a little bit about the impact that this lack of certainty in the law has had on the research and security community in particular?
Sure. I think in terms of impact, it's hard to say there's lots of security research that would have happened had the CFAA not been around. And in general, I would say security researchers are probably not the people who are most inclined to abiding by laws, especially laws they disagree with, as Justin raised. I do think that, and it's an issue I want to sort of highlight that's not unique to the CFAA. Those of you who are familiar with the Digital Millennium Copyright Act, which makes it illegal to circumvent technical controls that protect copyrighted works online, know that that's also been a big problem for some security researchers who have said, I was trying to do research on this kind of software or this kind of vulnerability, and somebody from a company came and said, if you don't stop doing that, we're going to bring charges against you under the DMCA and say this was a violation of our copyright protections. So if you're thinking about sort of some of the interpretation issues that Orin raised, right, he's been a strong proponent of the interpretation, correct me if this is wrong, I shouldn't assert what people sitting next to me think, of saying that unauthorized access in excess of authorization should be limited to cases where there's circumvention of technical and physical controls. Is that a fair characterization? Yeah. So if you think that's sort of a good narrowing of the law, you still run into some of the same issues you have with the DMCA, which is about circumvention specifically, where you have people saying, but what I do, my job is to figure out ways to circumvent technical controls. I don't do that because I'm a criminal, because I want to watch the world burn. I do that because I want to make the world safer from online criminals, because I want to find those vulnerabilities and I want to fix them, patch them, tell the right people, get that information into the right hands. And I think the big problem for both the CFAA and the DMCA is that the early stages of that look basically identical to the early stages of a crime. Right? When I am looking for a vulnerability in code, there is nothing I do up until the point where I'm actually maybe committing another crime, where I'm actually reading your email or stealing your money, that looks different in how I'm trying to find those vulnerabilities, how I'm trying to test them out. So there have been a couple proposals that I just want to flag around how you might try to carve out exemptions to laws like the CFAA for security research. And all of them, I would say, are flawed in some ways. Right? One, which will probably announce its own flaws with it, is that researchers should be a sort of designated group. Right? And I get a little researcher license, and then I'm allowed to look for vulnerabilities. And there are a lot of criticisms of that. But mostly, again, you come back to this issue that security researchers are not a group that generally likes to go around getting government-issued licenses and following all the rules and filling out a lot of paperwork. And there are a lot of people who are sort of doing security research in unconventional or unlicensed ways, who are not working at universities, who are not affiliated with a particular company. So there's also a set of proposals that instead of saying, depending on who you are and what your role is, you're allowed to find these vulnerabilities, have said, well, depending on what you do, you could be exempt. And again, there you run into that issue of, but you haven't done anything very different from what a criminal would do up until the point when something happens that you can say this was really bad, this was really harmful. At the point where you're just at that access stage, just at that trespass point, it's not clear that there's a distinction. One of the proposals that I think has some merit to it is around disclosure, around the idea that you should have some kind of exemption if you find a vulnerability and you report it properly to the right people, if you've made some steps to show, I'm not trying to take advantage of this Apple vulnerability myself, I just want Apple to know about it and fix it and sort of help people, which I think is a proposal that has some merit but also has some problems around how are people supposed to know what the appropriate avenues are for reporting, how much leeway do we give to companies and what they require of the people who report vulnerabilities to them. So I don't have a great answer to it. I think there are definitely people thinking about this and people worried sort of on both far ends of the spectrum. There are definitely people who think the CFAA is not broad or punitive enough. There are probably not a lot of them on this panel. But one of the things that I'm always struck by when I talk to people who are sort of interested in the CFAA is how much sense there is from people who are not in the technical space. Computer crime is a huge issue. Look at all of these hacks of the elections. We need to make this a stronger law. And on the other end, there are a lot of people who say, well, the stronger this is, the more security research you deter, the more unsafe the computing environment is for everybody, because you don't have these minds out there looking for these vulnerabilities because they're too scared.
That's a great point, though, the sort of optics of security research and how does one define that, and do the people making or sort of interpreting the laws even accept that a security researcher is a thing that exists or should exist, and not just sort of an excuse that someone who is caught is making to avoid punishment.
Which happens often.
Oh yeah.
Everyone's a security researcher who gets charged under the CFAA.
I mean, I'm thinking about the Andrew Auernheimer case right now. He's maybe better known as a hacker who goes by Weave. Weave's a huge jerk. Nobody likes him, right? He has made a career, so to speak, out of being a gigantic troll and sort of using, racist and inflammatory language. He was the
But as my former client, I want to say he did not violate the CFAA.
Well, yeah, and that's the thing, right? And you're definitely more qualified to speak to this case than I am, but the circumstances of it such that I sort of remember is he found sort of a website address that was very hard to guess, but he found it and it was not secured or password protected, and on that sort of page there was account information for AT&T account holders or something, and one thing led to another, and he was prosecuted, and he was like, well, how in the world could it be construed as unauthorized access if this stuff was literally on sort of a website that was on the internet that you could just find. And that argument didn't take, perhaps because, Weave was sort of a polarizing person who made us easy to dislike. But sort of the interesting, one of the many interesting things about this case gets into another thing that I hope we talk about is, well, how do you determine how to penalize people who are convicted under this law, and how do you determine what's an appropriate penalty? Often what they go off of is the sort of guideline sentencing for economic fraud cases, which requires an assessment of economic loss. And in the Arnheimer case, basically the only loss that AT&T claimed was $73,000 that it cost them to print and mail letters to their account holders, informing them that their account information was safe. If they had decided to just save the money and email everybody, the sentence that Arnheimer got would have been calculated differently than the one that he ultimately received. And there's a lot of sort of room for interpretation and gray area in there.
Yeah. I mean, from my own perspective, on the security research question, I'm actually really wary of the idea of having special rules for security researchers, in part because everybody claims to be a security researcher. Going back to United States versus Seedlitz, the first unauthorized access case in federal court, it was prosecuted under the wire fraud statute because there was no CFAA yet. Seedlitz is accessing his former employer's account and downloading software, and he says when he's caught, I was trying to determine the security limits of this, and I was going to then tell them, here are the security flaws on your network. And the jury didn't buy that, but that was his defense. And so we see that again and again. And I think saying, I'm a security researcher is just, look, what does that even mean? And more broadly, I think there is a really simple way of distinguishing sort of legitimate from illegitimate research from the standpoint of somebody who's, we talk about malice versus non-malice. There's permission versus without permission, authorization versus without authorization. And if you get the permission of the person whose network you're testing, it's authorized, and so there's no CFAA issue, clearly. The harder, the question here is when the company doesn't want you to do it, they say you can't do this, and you do it anyway, should that be okay because you're a security researcher? I mean, I get stuck on the physical world analogy of, if I wanted to test the security of people's cars or security of people's houses, could I knock on every door and try to open every door, open up cars, and say, no, this is for your own good. I'm a security researcher. I think, the police would say, well, enjoy a couple days in jail. And so I'm wary of that same argument in the online context because the point of the CFAA is protecting privacy. Sort of, I can invade your privacy. It's okay. I'm a security researcher. Doesn't I think work. On the other hand, the sentencing issue is, I think, a really important question. In the physical trespass context, we recognize physical trespass might be, a few days in jail, whereas the CFAA, unfortunately, the Sentencing Commission adopted this fraud idea. You think of the Sentencing Commission in the 1980s. They're trying to figure out how do you punish these new computer trespass type crimes. The statute was drafted as the Computer Fraud and Abuse Act. It was in the fraud section of the criminal code, and one of the provisions was computer fraud. And so what did the Sentencing Commission do? They said, well, this is a fraud case. Let's have these cases be sentenced under the fraud guidelines. Well, there's a real problem with that, which is that fraud guidelines base the punishment on loss. And that makes a ton of sense in a theft or fraud case because the amount of harm in a theft or fraud case is based on how much money was taken from the person defrauded. If you steal $1 versus steal $100 versus steal $1 million, makes sense that that would determine your punishment, and that's an incredibly important aspect of what the punishment is. CFAA cases, on the other hand, are trespass offenses, and the dollar value of loss becomes a consequential harm, which in all likelihood you, the defendant, did not intend. It's just sort of a random circumstance that occurred entirely unbeknownst to you, and most of the time in an unauthorized access, it's never caught, and so the amount of damage is zero because no one ever sort of said, hey, wait, there was a harm here that followed. And the problem is that the methodology for calculating the harm includes responding to the offense. So that's what happened in the Arnheimer case. The cost of mailing out the letter, which actually was just repeating an email that had been sent to people that was free, The cost for printing and mailing the letter was $73,000, and Arnheimer's sentence is like doubled because AT&T decided to send out the letter. It just doesn't make sense because the nature of the offense is trespass, not fraud. And so for that reason, I've argued, have a forthcoming article on this, that the Sentencing Commission should rethink the punishments for CFAA offenses to make it match the dynamics of trespass cases and not fraud cases. It's another one of these, this is consistent, good faith, hey, I think this makes sense, that in retrospect just didn't make sense. And it leads to a statute which is construed incredibly broadly and can lead to severe punishments in cases where you'd say that doesn't make a lot of sense because the conduct wasn't malicious or intentional as to the damage.
So, okay, interrupt you just for one moment. I wanted to just sort of ask you a little bit more about your perspective on the permission versus no permission for security research, because I'm curious, going back to the DMCA issues with security research, we've also had cases where researchers have, say, purchased software, back when that was something you bought on a CD, and tried to find vulnerabilities in that. If you've bought the software, again, let's think pre-cloud for a moment, does that sort of constitute you have some permission to test it out if you own a copy of it?
Under the CFAA, you know, it's the rights in the machine or use of the machine. So if you bought it, it's yours.
So I guess what I want to ask you then is, as we move to a world where that's less and less true, that you own any of the software, or that you're running it on your own machine, that you're sort of really relying increasingly on other companies' software running on their own servers for everything you do online pretty much. Does that shift at all the way that you think about what you need permission for? Or if you've entrusted yourself to the cloud, then you have no right to test that unless you've asked those companies explicitly?
Yeah, I mean, I guess off the top of my head, it's a great question. Off the top of my head, I would think, I suspect a lot of courts would find the physical world analogy of like leasing property. You know, if you rent rather than own, we don't say, well, it's the landlord's place, you're not allowed to do things that violate the landlord's rules. Instead, we say, like, you're renting, it's yours. It is your property. You can do whatever you want with it. And the landlord actually can't just sort of come in and do whatever they want against your wishes. And so you could have a similar idea in the CFAA context. I think you're absolutely right that it gets trickier once you move away from physical devices. It's this big problem that, you know, the statute is sort of assuming there's always a clear answer to who owns what, and I think it does get murkier in the cloud setting, but I suspect courts can solve that problem.
Although you have indicated that the courts have had a lot of difficulty coming to terms with some of the problems in the CFA now.
So maybe I should say courts are hopelessly confused on a lot of issues. That additional confusion hopefully won't be even worse.
I think it's worth mentioning here, just you brought up the circuit split issue. When I look at especially some of the decisions that came out of 3-judge panels on the Ninth Circuit this summer, I think there's even some disagreement within the circuits themselves, where you see people not necessarily following the precedent set by their own court, which is sort of striking. And I think one of the things, and I do want to talk a little bit about sort of some of these recent cases. You brought up the Facebook Vashani case. There was another one, a sort of more recent ruling in a case against a guy named David Nosel, also came through a 3-judge panel in the Ninth Circuit this summer, and found the guy who had been sort of found not guilty of unauthorized access when some of his colleagues used their credentials to download information that he used to help start a competing business from the company that they had downloaded it from. They then found that he was guilty of exceeding authorized access when another colleague gave her credentials to them and said, you know, you can download things with my credentials that have been shared by me voluntarily. And I think that the things that I thought were most striking in these cases were definitely in the Facebook case, the sense that, wait a minute, back in the first round of Nosel, the Ninth Circuit came out very clearly and said it's only exceeding authorized access if there was a circumvention of a technical control. And in the Facebook case, they said, but actually a cease and desist letter counts too.
So actually, I don't think we've gone through the Facebook v. Power Ventures case. Do you mind sharing a little bit about what that case entailed?
Sure. Yeah, so this is a civil case that was brought by Facebook against a company, Power.com, Power Ventures, run by Stephen Vachani. Again, full disclosure, I represent Power Ventures and Mr. Vachani. This is a case in which you as a user could use the Power.com software to aggregate your different social media sites, including Facebook, and it would all be available at the website Power.com. And basically, as a user of Facebook or another social media site, you authorized Power to go into your Facebook account and grab your contacts, grab your messages and the like, and bring it to Power where you could then view it. And Facebook did not like this. Facebook wanted Power to stop, and they did not cut any of the accounts of the users who took advantage of this service. They just sent a cease and desist letter to Power saying this violates our terms of service. You should stop doing it. Please comply with our terms of service. And the question is whether the contact subsequent to receiving the cease and desist letter was an unauthorized access. And the Ninth Circuit panel said it was an unauthorized access. They said merely accessing in violation of terms of service is not, but it's different. In this case, their rationale for why it's different, I think, was sort of, it didn't work. There were a couple different arguments they made that didn't quite make sense. One of them was, well, in this case, the Vachani, they knew that the access was unauthorized. And the problem is that's a different element of the CFAA. That's whether the unauthorized access is intentional or not. So it can't be used to distinguish what is unauthorized access in the first place. And that's a case where it's currently pending before the Ninth Circuit, the petition for rehearing that we filed, I guess, about a month ago now.
So wait, did the Facebook users give Power.com like permission to sort of use their data on this one, like on their website?
Right. Yeah. So the users were giving Power permission, and the users had permission. The question is whether using the permission of the users, who themselves were authorized, gave Power authorization. And what's interesting, the first Nozzle en banc case, this is the case that said terms of service violations are not a crime. In that opinion, the court actually says a lot of people give their friends access to their Facebook accounts, which is in terms of violation of the terms of service of Facebook. And the court says, that can't be unauthorized access. And then in the Vachani case, the court says, well, it doesn't matter that they gave permission. And the court focuses a lot on this idea that they knew they were not supposed to do this, and that was different. So the argument that we have made is that if you're a legitimate account holder, you can authorize somebody as your agent to access your account in the way that you might in a workplace environment ask a colleague, can you check my email, or ask a spouse, can you check my Facebook while I'm away? I won't have access. You say you're hiking in the mountains, there's no internet access, you want to make sure somebody is responding to your emails or something, and you can ask somebody to act in your behalf. And so our argument is that it doesn't matter whether Facebook said you can't do this to Power, because they authorized the Facebook account holders, and that meant the Facebook account holders could then extend their authorization to Power to act on their behalf. But the Ninth Circuit panel focused more on the idea that the cease and desist letter put Power on notice that Facebook didn't want them to do this.
Mr. Ramey, did Facebook also block the IP address that Power was using?
Yeah, so there was another aspect of the Facebook case, which is Facebook blocking the IP address and a little bit of cat and mouse games over IP addresses. That didn't become part of the Ninth Circuit opinion. It was an issue that was argued by the parties. Is blocking an IP address like saying, are you circumventing a restriction if you block an IP address? Or is that more just like somebody saying, don't look at me and you move around because people are constantly changing their IP address? It's not like your IP address is your identity. It's just kind of the path you happen to be currently taking to visit a public website. So that was an issue that was discussed in the case but not resolved by the panel.
Can I bring out a journalist question on this, about the journalism surrounding this case? What sort of coverage has the case received, and how good has it been, in your opinion?
It's received some coverage, I think, not as much as it should, I say, with a pending petition for rehearing before the Ninth Circuit. So the more attention, the better. I think these cases are hard for the press to cover. It's really easy to say, oh my gosh, it's a crime to violate terms of service. That grabs people's attention pretty strongly. It's a little trickier in this case because it gets technical, and it's hard for the press to cover the more technical aspects. One example of this that comes to mind, Facebook's response to the petition for rehearing said, well, it's important to realize that the users themselves are not criminals violating the Computer Fraud and Abuse Act, because even though they're aiding and abetting Power, they presumably don't know about the cease and desist letter. So you can cover that two different ways. You can say, internet users safe, or you can say, all internet users go to jail if they learn of a cease and desist letter. And the coverage I have seen took the former view, not the latter view. I'm more worried about the latter concern. So it gets a little technical, but there's been some coverage, not a lot.
I think, from my perspective, I'm biased because I write about some of these issues sometimes for Slate, so I'm perhaps more favorable to the journalism side. I think one of the things you've seen from journalists that's both good and bad is a lot more attention to sort of what the precedent will be out of these cases, and not just the Facebook case, but also the password sharing case I mentioned got a lot of coverage as court rules it's illegal to share your Netflix password, which was interesting both because if you go back to the court decision, they very explicitly say, the two judges who voted in the majority, this has nothing to do with password sharing, we're not talking about that at all, which is very confusing because it is a case about, right, whether or not you think that should be legal or illegal. I think you have a court saying, like, we're deciding a case that's about something, but we really don't want to set precedent around that. So we're going to say it's really not about that. It's about this guy who did something bad, steal secrets from his old employer. And I think one of the things that journalists do that's, as I say, both good and bad, is they say, well, but you can't just make this ruling as a high-level court and not think at all about what it means in the broader context for other internet users. I think the same thing is sort of true of the Facebook case, that the court doesn't say, when I read that ruling, it's illegal to ever go to a website when somebody tells you you can't. Right? That's not exactly the precedent that they see themselves as setting, I think. Either that or it is. But that when other people look at that ruling, they say, well, aside from this one particular guy in his company, which you guys think should be guilty of something, this is what that means for everybody else. And I think that has not been a strong suit of a lot of the court decisions I have read from the CFAA, sort of thinking with an eye to what precedent this sets. There's much more instinct to sort of say, here's a guy we don't like, here's somebody who we think did something bad, and we want to make it clear that you shouldn't do things like this, but we don't really want to make it clear what you can and can't do, because that's really hard, right? That's really hard to say. These are the appropriate norms for computer use. This is what, and I think if you're a high-level judge, and easy for me to say because I'm not one, then you have to be a little bit more attentive than we've seen some of these judges be to kind of the question of what is the overarching precedent that these rulings set.
Well, is it? Oh, sorry, go on.
No, I think that's exactly right. The courts don't want to set too broad a precedent, and so they're handing down some cases to just kind of say, in this case, we hold the CFAA was violated. And the problem is it's a criminal statute, right? And so you're trying to figure out what can you do without being arrested by the FBI and hauled into jail and maybe spending a couple of years in prison. And if you want to know what you can do, the courts just say, effectively they're saying, listen, you'll get arrested, you'll be charged, you'll be convicted, and then on appeal, we'll figure out whether your conduct is a crime. And that doesn't work. In fact, that was the problem that courts had before the CFAA, that they would ex post try to figure out what was a theft. And now they're trying to figure out afterwards what was a trespass. But they need a set of principles to put people on notice as to what you can do legally and not do illegally, legally. And in part, that's because once there's a clear answer, then you could actually have the potential for statutory reform one way or the other. Right now, there's these just two dramatically different ways of thinking about the CFAA, the narrow approach and the broad approach. And courts are just sort of dabbling in some of these answers, or narrow in one case and broad in another case. And you look at two cases, you're like, even in the same circuit, I can't figure out how to reconcile those. And until there's a clear answer, the Supreme Court stays away, and Congress says, well, let's let the courts figure this out. So we need clear answers one way or another for there to be reform going forward, and we just haven't had that yet.
Yeah, I mean, it sort of seems like a lot of the trouble is that courts don't know what the norms for behavior online should be. But a part of that problem is now it's actually potentially stymieing what norms for behavior will become, because people don't really know what is and is not allowed online.
Yeah, I mean, so it's important to recognize, as Orin said at the beginning of this panel, that there are only basically 100 or so sort of CFAA prosecutions every year. I think the law and its broadness, has a deterrent effect, but not like hugely like that much. I think people are still, going out and sort of planting their flags wherever they can, find them, and it's only in the sort of rare occasions that people actually end up getting caught and like prosecuted. And I think that is where sort of the press comes in. When the press does get wind of some of these cases, I think more and more, internet native, journalists are a lot more apt to say, wait a second, why is this a crime? Why should this be considered a crime? Isn't this more just the way we live now? Sharing passwords, no real malicious sort of intent, and it feels like the law that governs these incursions is not ignorant of the fact that the norms have shifted, but rather perhaps more favorable to sort of the bigger corporate interest who would prefer that the norms hadn't shifted, or that sort of the shifting norms might end up sort of imperiling their ability to make money. I think it's a certainly super interesting thing to note that you sharing your Facebook password with a guy, just your friend or your mother, you're not going to get prosecuted. Share that Facebook password with a guy who owns a company that hopes to sort of profit by aggregating your social media profiles in like one place. Certainly that becomes a much bigger concern to a company like Facebook that wants to have you do that wants your social media browsing to be disaggregated. And the sort of gap between norms and expectations is one that it's been super hard to bridge ever since digital computing began.
I tend to fall into the camp of people who thinks that it as a law, the CFAA has not deterred a lot of legitimate computer use or a lot of illegitimate computer use, and it's hard to base that on anything because we don't know what the world would look like without it. But I think that, first of all, the people who are charged under the CFAA, with all due respect to them, are usually not the really savvy cyber criminals who have built up large organizations and devoted a lot of time and effort to committing large-scale crime and hiding their identities, because most of them are not based in the United States, and most of them are doing things that make it hard to trace them or trace them back to people who US prosecutors can charge. So I don't think we've seen a dramatic decrease in necessarily the number of people who are doing things that we don't want them to do with computers. I also don't think that we've seen a dramatic shift in the way that legitimate users use computers. I don't think a lot of people stopped sharing their passwords after the second Nozzle case made headlines this summer about how password sharing was illegal. I don't think a lot of people stopped giving their credentials to other websites to access their social media accounts when that ruling came out. I think there's a pretty strong sense, and it's a pretty accurate sense, that if we're all criminals for violating terms of service agreements, probably almost none of us are going to be prosecuted for that. And that's true. I think, as Orin said, there are 100 prosecutions a year maybe. I think the issue then becomes, if we're all sort of walking around with a possible crime attached to us, what is it that triggers for the people who do get charged, whether or not they get charged? And is that necessarily about the way they use computers, or is it about something else that happened and the computer use was sort of more peripheral or tangential? The case I always come back to, and that a lot of people come back to, is another case that Orin has worked on about a woman named Laurie Drew who created a fake MySpace profile for a fictional 16-year-old boy and used it to bully a classmate of her daughter's, a 13-year-old girl named Megan Meyer, who then committed suicide. And as in the case of Aaron Swartz, the suicide was really what drew a lot of attention to the case and what made it a big deal. Not so much, I would argue, the computer piece of it, but it became a CFAA case, and around this question of had she violated the law because she violated MySpace's terms of service. And the issue then becomes, well, okay, so if all of us have done that, then how are we picking out the people who are getting prosecuted for it? And are we just saying, well, but then a girl committed suicide, so let's exercise our right to prosecute this thing that all of us have done?
Well, sorry, go on.
Just briefly, if you want to know why we should worry about broad readings of the CFAA, I think we can answer that in 3 words. President Donald Trump. Imagine Donald Trump is elected in November and the Justice Department comes to him and says, hey, guess what? Anybody who violates the terms of service on this cyber internet thing, we can arrest them legitimately. It's a crime, and we can put them in jail. And all of your political enemies have, in fact, violated terms of service because everybody violates terms of service. Should we arrest them? You have the power if you want to. I don't want to. Well, I don't want that in a number of reasons. But we don't want to have a president who has that kind of discretion. We don't want law enforcement to have that kind of discretion. Criminal law is about harms, about serious harms, about acts that cause substantial wrongs and involve culpability and the like. And because the CFAA is drafted in this vague way and has been interpreted in the civil context to mean these broad things, it's potentially giving this enormous hammer to law enforcement. And it's true, one of the responses law enforcement gives is, we're not going to do this. We're not going to use this in the broad way. And the problem is, we don't expect to do this is not a very good, very comforting thought when you don't know who the next president of the United States is going to be.
Yeah, you don't, I'm not comfortable leaving it with, trust us, like, you're not a jerk, like, we're not going to go after you. Well, okay, great, like, at some point there might be someone in power who thinks I'm a jerk. Maybe I wrote something that really sort of bothered them, like time ago. Like, maybe they just don't look like the way I look, Like, and it seems sort of, comical to, say that a prosecution might be generated thanks to these sort of, broader like factors. But, one of the reasons why we're here is, the law is so broad and the prosecutions under it, vary so widely that, one can reasonably say, well,
but because of who he was, it became controversial.
I think that's fair, but I also think that what he did not ring to people, oh, that should send you to jail for 30 years.
I also feel like if Aaron Swartz hadn't been Aaron Swartz, there's a decent chance the prosecution might not have even gotten off the ground at all. I've went through thousands of pages of Secret Service documents and sort of internal communications from sort of the prosecutors and the people who were sort of trying to build the case against him in the sort of 6 months before the indictment came down. And some clear takeaways with that is, well, this guy has, he's a quote-unquote big hacker, right? That's the phrase that sort of recurs in some of the internal correspondence, a big hacker. He's sort of spoken about the moral necessity of sharing information online, and it's plausible that he might have some sort of connections to broader hacking groups like Anonymous or sort of like WikiLeaks. And I know that one of his former girlfriend, Quinn Norton, she was the person who told the prosecutors about this document that Aaron wrote called the Guerrilla Open Access Manifesto. And one of the things she was really worried about and why she gave them that information was, well, she had done a lot of reporting on Anonymous and sort of bigger like hacking groups. And they very much sort of made the threat to her, look, if you don't give us something, like we might seize your computer here and sort of seize your in sort of correspondence with these people and try to roll everybody up. But back to the question about who this law is intended for and why it keeps on expanding. Twice now after Aaron Swartz died, bipartisan coalition has proposed a CFAA reform act called Aaron's Law. What Aaron's Law would do is it would make it harder for prosecutors to bring redundant charges against defendants, to basically charge them twice under the CFAA for the same sort of offense. And it would make it harder for them to prosecute people federally for mere terms of service violations. And twice now, the bill is stalled in committee, and when the current Congress ends, it's guaranteed that this bill is going to expire. And Ron Wyden says, well, I'm going to keep on introducing it. and it's going to keep on getting stalled and expiring. And one of the major reasons why is, well, there's a lot of corporate money being expended lobbying against CFAA reform sort of acts. And I think it's worth bearing in mind that many of the most valuable tech companies in the world are the ones that are most sort of avid about keeping the CFAA very sort of like broad and very tough to deter theft and corporate espionage, and to make it easier for them to sort of try and deter disaffected or former employees from taking information garnered when they were employed and going to start another company or stuff like that. And that's, to me, one of the major sort of reasons why this law continues to be as broad as it is.
So also along the lines of some efforts to sort of make the CFA even harsher, are proposals to make the CFA applicable to racketeering laws, RICO laws, that are targeted toward organized crime. What kind of impact would that have, do you think, on prosecutions? Could you see prosecutions increasing? Would sort of more people get wrapped up if they were even merely associated with someone who had violated CFA? How would that play out?
It's actually not entirely clear to me what the implications are of making CFAA crimes RICO crimes. Although I also have, in trying to push people to find out why make it a RICO crime, I've never gotten a good answer to that. So there's a little bit, sometimes Justice Department criminal law reform proposals can kind of be parodied in predictable ways. They're sort of, let's expand the law, let's make it more punitive, let's add civil forfeiture, and let's make it a RICO crime. And so I think some of it may be an instinctive reaction to do that, but it's not obvious to me what actual changes it would make.
Yeah, and I mean, I think one of the other things that's been notable is DOJ and the FBI have really been amping up their resources and their efforts directed toward computer crime. And so is this something that could conceivably heighten the number of prosecutions? And in light of that, I mean, it seems like actually getting more clarity about what does it mean to violate the CFA? How do we define these terms? And what are appropriate penalties? It seems like it would become really a matter of more urgency. Do you forecast increased prosecutions because of the increased resources that are being dedicated toward these kinds of investigations?
That's an interesting question. I don't know if I forecast more prosecutions. I will say that while typically I would think with time comes clearer precedent, I am less convinced of that in the case of the CFAA, just because here we are 30 years later. And as I say, just this summer, I feel my understanding of the precedent has shifted pretty dramatically, with decisions coming out from courts that I thought I knew where they stood on some of these issues. So I don't know that I think the more cases we hear, the clearer it becomes what the restrictions are, what the definitions are in the context of the law. I've sort of been struck by the extent that hasn't been the case. That lots of laws are ambiguous, lots of laws require clarification and have missing definitions that would be useful to the courts. I don't see a very clear movement towards consensus over the first 30 years of the CFA's life, at least. So I'm less persuaded that if there's more prosecution and there are more cases and they're brought to circuit courts, we will clarify that more as opposed to less. But I could be wrong.
And I'll just reiterate something that Josephine said earlier, which is that it's really, really hard to catch the really, really good cyber criminals out there, many of whom are located overseas, many of whom are, just as, if not more, adept with computers than the people who are trying to catch them. I don't think that computer criminals are going to get stupider. I think they're going to continue to, get better and better.
And I would guess the legal uncertainty as to what unauthorized access means will probably, at least in the short term, lead to fewer prosecutions rather than more, because it becomes harder for the government to bring a prosecution based on a theory that the Second Circuit rejected, the Ninth Circuit rejected, and it becomes a trickier issue for them to rely on On the other hand, you get still tons and tons of civil cases. If you look in Westlaw for just do citations for CFAA, and 95% of the cases, more probably, are civil cases, and it's business-to-business litigation, and they keep going. So we'll probably see the issues under the CFAA resolved in the civil context, even though it's primarily a criminal statute.
So a lot of the tension that, you in particular, Justin, have raised is between sort of like what are the civil interests, the corporate interests in applying the CFAA versus, when is something a crime? When should someone go to jail for violating the CFAA? Is anyone making the argument that because it's so hard to figure out what is a violation of the CFAA and because sometimes corporate interests might overtake individual interests in terms of just who has the power to bring suit, should the civil aspect of the civil penalties in CFAA be taken away? Should Congress act to actually remove those civil penalties and just leave it as a criminal statute?
Yeah, so I've been urging this for years. I think it's just a big mistake to mix the civil and criminal remedies because the cases come up in such different contexts and courts can't distinguish. They don't think about the broader context when they're interpreting the statute. So I think the assumption Congress had, and I think it was in 1994, when they added civil remedies, that there were going to be all these cases and that the victims of hacking were going to sue the hackers. I mean, think of this, like, how's this going to work? Is Google going to sue the 19-year-old who has no money, saying, you caused $10 million of damage and you better pay up or else we'll suspend your Gmail account? It doesn't make any sense that you're going to have civil. I've never seen a civil case against an actual kind of what we might think of as a hacker or somebody who you could imagine being charged criminally. And so I think the civil remedies just don't make sense. I've made that argument. A couple others have made that argument as well. The tricky thing, as Justin points out, is that you've got companies that are vested. They say, hey, wait a minute. This is a law that can be used by network owners. We're network owners. We can use this against people who mess with our networks. And so you have companies that want to keep it, and then the broader problem that Congress these days doesn't pass laws. So in the 1980s, give them credit, they passed a lot of laws. These days, they don't. So we're stuck.
Certainly for some companies on the civil side, and I sort of feel like I should name names since we're talking about tech companies. The one that's really been opposing CFAA reform is supposedly Oracle, which has spent a lot of money lobbying against Aaron's Law in particular. And there are also a lot of tech companies that have been taking steps that would suggest they're increasingly less interested in trying to use the civil penalties, at least against security researchers. So going back 45 minutes when we were talking about research, one of the sort of efforts that we've seen take off in the past 2 or 3 years has been what are called bug bounty programs, where tech companies say, not only are we not going to bring civil charges against you if you find a vulnerability and you report it to us instead of exploiting it for your own gain, but we'll actually pay you to report those vulnerabilities if we think they're useful. And that, I think, has changed some behavior, not just because of the sort of diminished threat of civil action under the CFAA, but also because of the promise of financial gain for researchers. I think that is definitely sort of a different approach from just saying the CFAA should stand and should not get any narrower, to try and say we're not going to exercise those civil remedies. But to say that you're going to do that for security researchers who do security research you think is valid is still a very, very different thing from saying there are no civil penalties at all, because that still leaves a lot of wiggle room to say, well, you're not a real researcher. This is not, you didn't have our permission. And if you're going off the sort of permission standard that Orin proposed earlier, then the question of sort of whether setting up a bug bounty program constitutes some kind of implicit permission, I think, is an important one, and one that hasn't been totally resolved.
More broadly, I think it's sort of a mindset thing, right? There are a lot of laws that govern the way we act and interact online that provide for the imposition of civil penalties if a law is broken, or give rights holders the opportunity to sue someone who has taken something that they should not have taken. I'm thinking specifically about the RIAA prosecutions back in 2002, when the recording industry was trying to put file sharing back in the box and then bury that box deep in the Earth's core, and they, the RIAA sued about 300 downloaders. Full disclosure, one of whom was my mother. And my mother she was named Woman of the Year by her church. She's never sort of downloaded anything illegally in her life, right? It was like my teenage sister who was unaware of what copyright or rights were, who had used Kazaa to download some tracks by some forgettable pop bands, and lo and behold, there's a process server at our door, saying that we owe $30,000 to the RIAA, and I think we ended up paying it because it's like, oh my God, like we're criminals now. And that's the thing, right? That did nothing except make my family poor. It didn't stop like illegal downloading. Like it feels so like the audible gasp, like is because like it's so arbitrary, right? Why this lady and not some other lady? Why are we prosecuting this dude under the CFAA and not this dude, right? There's so much room for sort of discretion in all of the sort of cyber laws that we have, and I don't know. I
think what you bring up around copyright is also sort of important thematically for thinking about the CFAA, which is a question I wrestle with a lot, and I don't know that I have an answer. If there's something that all of us are basically doing every day online, does that mean it should be legal? And I think that's sort of more poignant in the context of copyright infringement, where it's harder to say just because everybody's downloading something or streaming something that should obviously be legal. But it comes up a lot when we talk about things like violations of terms of service, and even when we talk about narrower definitions, when we talk about, well, everybody violates terms of service, that shouldn't be a criminal act. Let's just restrict it to circumvention of technical controls. I think there's a whole nother nest of issues within that definition about, well, so if I circumvent an IP block, something Aaron Swartz did, something Steve Vashani and his Power Ventures company did, is that circumvention of a technical control, right? If even Justin's mother could do that, right? I don't know if your mother could do that, but if it's something sort of so basic and so easy, and people are doing it all over the place for perfectly legitimate seeming reasons, then sort of to what extent do we want to craft this law around what are the existing norms of behavior online, and what are the existing accepted activities, and to what extent do we want to be sort of starting from a blank slate, the way Congress probably was in the 80s, and trying to imagine principles that should guide this?
I was talking before this panel started about the very first hacker who was ever brought to testify before Congress. It was 1983. His name was Neil Patrick. He was maybe 15 years old. He was part of a group that the media dubbed the 414 hackers after the area code for Milwaukee, Wisconsin. And
is that a big hotbed of hacker?
It was where some like 7th graders like had like access to a computer and a bulletin board, thanks to like their school. Right? And like Patrick was brought in to talk, and this was part of the discussion that led to the first rudimentary version of the CFAA in like 1984. And it turned out that what he had done was hardly anything at all. He had found a list of default passwords on sort of an online bulletin board, and had gone around and testing out some of these passwords at companies or whatnot that had been too lazy or stupid to change their password from the default, And I think to bring it back to the CFAA and sort of the broader issues here, a lot of the laws that govern, how we act online are basically there to insulate individuals and companies for getting better, for like doing a little bit like better to protect their goods and services online, and doing a little bit better to bring people in to want to participate, rather than presenting this sort of aloof, indifferent sort of like face that makes people want to just like turn away from it. I don't know.
So on that note, I do want to give folks in the audience a chance to ask some questions. So we do have someone walking around with a microphone. So if you do have questions, I just ask you to please use the microphone and also ask a question with a question mark at the end.
Yeah, I have a couple questions. One is the violation of terms of service if you're not actually trespassing. How is that line drawn? It sounds like, especially with the Lori Drew case, it wasn't really fitting the trespass model, but she was still prosecuted. Is there a type of violation of terms of service that doesn't apply, or is it too broadly interpreted? And secondly, some examples of civil actions that are used are used instead of the criminal actions would be interesting too.
Sorry, I just want to clarify. You're saying Lori Drew violated terms of service, but why didn't she trespass?
Yeah, that's not really trespassing because she had an account on the service. So how is I thought CFAA was.
So the idea of trespass, and you should correct me if I'm going to get this wrong, I think the idea of trespass is that by using the MySpace servers, the MySpace service, that was the act of trespass because she was only authorized to use those servers in a specific way, stated in the terms of service. So the trespass was using their service in a way that they had not authorized. So they would have said that was trespass. And again, not physical trespass, and like she went and stole the computer from MySpace.
But the physical analogy would be like if your friend had given you keys to use their house for a very specific purpose, like watering their plants while they were gone, and instead you used that house and threw a party or something, and it would be in violation of the agreement that you had made.
Would you be prosecuted?
I don't know enough about actual trespass law to know if that would be
In the
property
party case, I have no
trespass.
idea.
It may depend on the state law. Good question. No obvious answer.
But any examples of civil actions? What kind of civil actions would be allowed?
So probably the most common civil action is the disloyal employee case. Employee at company A wants to start a competitor company, and before he does so, he looks through the computer at company A and says, oh, I see their product has the following feature. I need to think about that, and I'll remember that. Leaves the company, starts competitor B, and then company A sues him at company B and says, well, you accessed the computer without authorization because you were looking through our servers to help you when there's an employment rule at our company that says you're only allowed to use the network for company use, and that wasn't company use. Lots and lots of those cases is probably the most common.
And even sort of between competing companies where a former employee doesn't necessarily steal confidential data, there are civil cases where they're, say, trying to scan their website and undercut prices or other kinds of access that companies have alleged is unauthorized, even if it didn't require any privileged credentials.
Yep.
Hi, I'm Kathy Kleiman. I run the Internet Law and Policy Practice of Fletcher Hilton Hildreth. And years ago, when I became a data security auditor with Price Waterhouse, my partner gave me a copy of The Cuckoo's Egg by Cliff Stoll and said, go through it and find all the default passwords and use them when you're auditing because they're probably still being used. So are you telling me it's illegal to get them if you get them online, but it's okay to read a book that you get off the bookshelf and use those default passwords? But the bigger question has to do with our children. One of the essences of criminal law is that you have to have mens rea, that you're doing something illegal. That's what you learn the first day of criminal law. If our children are regularly doing things that A, everybody else is doing, and B, they have no notice that they're violating a terms of service because they're so incredibly complicated. My children may be the only ones who read terms of service before they log on. That is a requirement. Then what can we do together to make sure that they are not liable for, this is insane. What you're describing is kind of an insane situation. We don't want our children, we don't want people who don't have any knowledge that they're doing something criminal to kind of turn a corner and find out they might have been doing something criminal. So who's organizing? What can we do together to make sure this doesn't happen? It's an incredible liability, particularly for children.
So to your first question, it's not illegal to read the book. it is illegal to use those passwords in systems that don't belong to you and see if they work, unless you're auditing, in which case you probably have a contract to test out those systems. And I mean, I think when you were with PricewaterhouseCoopers, if this is relevant, you were fine. But if you just like check out my email account and say, I wonder if Josephine has the default password, and it works, that is illegal. Even though you're on perfectly safe ground reading the book. I think a lot about the question of what we're teaching kids coming up studying security issues in particular, because that's what I do in my daily job. We don't have a law school. I'm not a lawyer. I don't train lawyers. I teach cybersecurity law and policy to security majors who are going to go out and do security engineering work after college. And mostly, I think, and of course I think this because it's what I do, it's important for people to have some understanding of these laws and what they mean. And in order for people to have that understanding, we need a better understanding as a country and as a legal system of what they mean and what the definitions are. I also think it's really important for people who do technical work, particularly perhaps security-related technical work, to be a little bit literate with what some of these restrictions are. I don't think that it is a good enough excuse at this point to say, and lots of security researchers would probably say this, I'm a technical guy, I go out and I look at code and I don't care what the law says and that's not my issue and that's not my field. I think that we're past the point where that's either a sensible approach on their part or really a reasonable one for them to feel that the law doesn't touch them. There are a lot of really hairy things that come up, even if you're basically a well-meaning person who just wants to test out computer systems and see what works and what doesn't work. And I think that's an important component of trying to teach people technical material now.
It's interesting, though, because so much of education today seems to be, trying to encourage kids to get really good, with computers, and to recognize that, look, if you want to be sort of successful or whatnot in the future, you should become sort of adept with these things. And then, while simultaneously trying to instill this sort of curiosity and this sort of maker-like mentality, there's also the laws that say, but okay, don't be too curious, or don't. You should also be curious about the laws that want to dissuade people from having this sort of maker mentality. So it's a very sort of discordant thing, and I don't really know what the sort of answer is, other than just guess that they're probably not going to prosecute your kid, but then your kid turns 18, and then I don't know, it's a tough question.
Yeah. On the mental state question, briefly, so the crime is intentionally accessing without authorization or exceeding authorized access, and that does not mean that you need to intend that it be a crime, but that you intend the act which is unauthorized. And this came up in the Lori Drew case, where on the government's theory that violating terms of service of MySpace was a crime, they needed to show that Drew knew of the terms of service violations. And they had no evidence that she'd ever read the terms of service, because nobody read the MySpace terms of service. Instead, they argued, well, Drew at some point later on said she probably shouldn't have done what she did, and that impliedly meant she must have gotten that information from the terms of service, which strikes me as an incredibly weak argument. And I thought, well, how could the jury actually convicted on this theory, and I thought, how could the jury possibly convict? They interviewed the foreperson of the jury, and she said, I always read terms of service, and that anybody who doesn't read terms of service should go to jail. Man, and I thought, what are the odds of that being on the jury? So, yeah, so apparently there are some people that read terms of service. I certainly don't. We're here because we're worried about the broad scope of the CFAA, and it's, the courts are aware of the problem. Fortunately, the trend in the cases is towards narrower readings of the law. It fits and starts. It's not clear, but that's been the overall trend. So there's reason for hope. It's just going to take a while.
All right, so we have time for one more brief question. Mike?
Mike Nelson with Cloudflare. I know the focus is on domestic law, but I spend half of my time worrying about what's happening elsewhere. So I'd be interested if anybody has seen another country that has tackled this problem a little bit better, written a better law, and whether you agree with me that the Wassenaar arrangement, which also tries to tackle some of these problems, is probably the worst treaty ever written in this area.
Yeah, so the other countries that that I know of and have looked at said, well, what is the leading country in the world when it comes to the internet technology? Let's follow the United States. So I think it's 60 or 70 countries now have unauthorized access statutes, basically based on U.S. law. And the cases I've seen, I only can follow the ones that are in English, but there are interesting cases from the UK, for example, trying to grapple with exactly the same concept, the same language in another jurisdiction, in the UK. So everybody's dealing with the same problem because they're all trying to follow this trespass idea without a clear understanding of what trespass means. So all these countries are in the same boat. We just haven't come up with the answers yet.
Yeah,
It's all our fault.
I mean, uniformity is like something that the world strives for in a world of sort of like free trade, and I don't foresee that changing really.
Right. Well, I think our time is up, so I just want to thank our panelists so much for taking the time to join us for this very interesting and timely discussion. Hopefully in 30 years we can come back together and talk about how we have fixed all of these problems.
And not created.
It's probably going to take 30 years.